A very good morning to all of y'all. I welcome y'all to this channel where we are taking one chapter and completing it in complete depth. Okay, this is called as a chapter marathon where we take one chapter which normally troubles the students and those chapters we cover it in 1.5 2 hours. Now, before I start, I need a confirmation from all of y'all whether I'm audible and visible. Okay, the chapter that we are going to cover is your compromise, arrangement, and amalgamation. Your compromise, arrangement, and amalgamation, which is your section 230 to 240, and it is there for old syllabus and new syllabus students. So, it is for old and new syllabus students. Okay, so for both it is there. Your sections is your section 230 to 240 and your chapter 15. Now I will ensure that it is completely memorized for all of y'all. Okay, it is the sections are also memorized, the chapter number is also memorized, and the form numbers are also memorized. Before I start, a very good morning to all of y'all. JB, Advocate, Renu, Karpangam, Anaga, Sham, okay, Vishnunath, good morning to all of y'all. Okay, quickly, so before I start, a request that you can share it in among all your friends. Share this video so even they can attend it live. Okay, so GTG in the chat box. First, just if you can share it in your friend circle, the lecture will be purely in English so that the students from the southern region can also understand. Okay, Sham, great. Niranjana, great to have you all. GTG in the chat box and we start. Okay, once we start, we'll complete this entire topic. Okay, compromise, arrangement for both old and new syllabus students. You can open your module and keep. Okay, you will get it, all of it. So GTG quickly in the chat box so I can start. Okay, Ranchu is ready, Shruti is ready, Niranjana, great. Okay, so just a small disclaimer before I start with the lecture. Pay attention. You all have to keep your book and pen ready. You can keep your module, whatever study material that you have, keep it ready. As I complete, you have to note down all the key form numbers, key chapter numbers, key sections, and the key concepts that you have understood. And by the end of 1.5 hours, I assure you this full chapter will be a cakewalk for you and you will be able to crack this entire chapter. Okay, so without further ado, let's start with the lesson. And also you all can join the WhatsApp group. It's in the description of this video. Okay, please join the WhatsApp group. So whenever we take any revision sessions, marathons, etc., a lot is planned for the December attempt. Okay, so go ahead and join it. Hello, yeah. Hi, so we'll be starting with a very important topic called as mergers and amalgamations in company law. Now, your mergers and amalgamation in company law is covered in your chapter number 15 of the Companies Act, section 230 to 240. The title of this part is called as Compromise, Arrangements and Amalgamation. So, one very important thing, M&A is covered from section 230 to 240 under the Companies Act. Now they have mentioned three keywords. One is compromise, the other one they have said is arrangements, and the third one they have mentioned is your amalgamation. So just a quick understanding of what are these three things. First, when they say that a compromise has been entered, a compromise is a mutual settlement. So can I say a compromise is nothing but a mutual settlement by the parties, settlement of some of the dispute of a dispute in the company. Okay, this compromise is normally with the creditors of the company. It is normally with the creditors of the company. With creditors. Okay, let's see. For example, Jet Airways, they had taken a loan. They had taken a loan from the creditors of the company. Now soon Jet Airways became loss making. It became a loss making company. So it could not repay the loan. So therefore the creditors and the shareholders of the Jet Airways came together. They said, now what should we do? So the creditors said, okay, fine, we are ready to reduce the loan amount provided you give us XYZ things. So whatever this agreement or this arrangement was held, it will be called as a compromise. Okay, where creditors are ready to take a haircut. Haircut means what? They say, okay, fine, now there is no use in pursuing the loan and filing a case and shutting down the company. Instead, let's have a mutual agreement with the shareholders and try to make a win-win situation for both of us. So this is called as a compromise. Now we'll see when there is a compromise entered also section 230 to 240 will be touched upon. Second, if a arrangement is done by the company as well. Sir, what is a arrangement? A arrangement is also called as a restructuring. Is also called as a restructuring. Sir, what is a restructuring? A restructuring means to rearrange, realign or reorganize the company in such a way that the objective is achieved, in such a way that objectives of company are achieved. For example, arrangement could be anything. If the company wants to do something called as a reduction of share capital, it is an arrangement. If the company wants to consolidate or subdivide its shares, so this is also some kind of arrangement that the company has done. So even that is permitted. So what is an arrangement? A arrangement is a wider term. It includes any kind of restructuring that the company wants to do to work better, to work more efficiently, is called as an arrangement. Now third, we talk about amalgamation. Sir, what do you mean by amalgamation? Amalgamation in general language or in common understanding is called as a fusion or absorption of one company of one company into another. So what is the keywords? The keywords are amalgamation is a fusion or absorption of one company into another. So let's understand. I just told you that amalgamation could be called as a fusion or absorption of one company into another. So let's take a small quick example. When company A plans to merge with company B, okay, this is called as company AB, where A will shut down, B will shut down, and both will work together as company AB. So what has happened here? It is called as a fusion. It is called as a fusion where both the companies join hands and they plan to operate together. This wind up the older companies. This fusion is also called as merger. This fusion is also called as merger. So amalgamation is a wider term. It includes mergers and it includes other things also. Now what is others? Let's see. When company A and company B plan to work together, what do? Company A is shut down. Company A is shut down. All its business is transferred to company B. And company B will survive. So we can say this will be big B because it is including company A got absorbed in company B. So company A is absorbed in company B. Clear till here? So A got fused into company B and A will shut down and B will work as a larger company. So amalgamation is a wide term. It includes pure fusion and it also includes absorption. Okay. So this is a common understanding where two companies join together and operate together. Now all three are covered under your chapter 15 section 230 to 240. So compromise, arrangements and amalgamations are covered from your section 230 to 240 and it is given in your chapter number 15 of the Companies Act 2013. And the rules are prescribed in your company CAA rules 2016. Compromise, arrangement and amalgamation rules 2016. So remember that the rules are in 2016. The chapter is in chapter 15 and section is section 230 to 240. Now I will show you a very simple technique where you will remember all the sections after this particular explanation that I give you. All the sections 230 to 240 will be on the tip of your tongue. Let's see how. Now section 230 to 232. Section 230 to 232 is called as the NCLT route. It is through the NCLT route. It is your amalgamation or compromise through the NCLT route. So here in section 230 to 232, which is your normal process. It is your normal scenario, normal process. So now if today someone will ask you that a company wants to enter into a compromise, arrangement or amalgamation, how do they do it? So they will have to go to NCLT and get NCLT approval. In this, all the three you require NCLT approval. 230 to 232. However, section 233 says that all the companies don't have to go to the court where a very long, lengthy process is there. They can come with a fast track manner like smaller companies, holding subsidiary companies or startup companies which are small in size. What they have said, or we do not attract the larger public interest. So they said, why send them to NCLT? We will just make a method for them to merge in a fast manner. So this is called as fast track merger. Fast track merger is in your section 233. Now, why think only from India perspective? Think a little more global. When I say global means what? The very next subsection is about cross-border mergers. Where one company is merging with a foreign company. So it is merging with a foreign company. It's a merger or amalgamation with a foreign company. Okay. So normal merger process, short form merger or called as fast track mergers or cross-border mergers. Now your compromise, arrangement, amalgamation is a very wide term. It includes takeover also. So we saw mergers. It also includes takeover. Now takeover is covered in 3 different sections. Okay. The assents is given in three different sections: 25, 235, 236 and 238. 235, 236 and 238, which talks about takeover. It talks about takeover. Now, takeover is given under 235, 236 and in 238. Okay, so very simple. Now, section 237 talks about a arranged marriage. So, arranged marriage. So, when central government feels that two companies should merge in public interest, it is covered under section 237. So, central government will feel that Air India and Indian Airlines should merge, or this bank with this bank, which is both public sector bank, they should merge. So, central government will give a compulsory order for those companies to merge. That is like a arranged marriage where the parents are feeling that the child should marry. Okay, and why? Because for society, for public interest. So, we will see. So, we can say it is a central government merger, compulsory merger in public interest, to make the relatives happy, etc. Now, 239 says that if the merger is there, should we throw the books or we should preserve the books of M&A? So 239 says after you've done all the CA things, then please preserve the books, do not dispose of until central government orders. So that is given under section 239. And if you don't comply with any of the provisions, then the penal provision is given under section 240. Let me see your memory and let me see whether you have understood it or not. Section 230 to 232, what is it? Quickly. It's called as your normal merger process, which is that you have to go to the NCLT. It is also called as NCLT route. So to do this, you need to take approval of NCLT, National Company Law Tribunal. However, not all the particular mergers have to go through NCLT and a long process. Government under the very next section has made something called as a fast track merger. They made something called as a fast track merger. It is given in your section 233. It's called as FTM. Next, think global. So you have your section 234, which talks about cross-border mergers. It talks about cross-border mergers, okay, which is your CBM. So it is when an Indian company is merging with a foreign company. So that's your cross-border mergers. Now we finished about mergers. Now we'll talk about section 235, 236 and 238. What does it talk about? Can anyone tell me? It is called as takeover. It covers provision with respect to takeover. And specifically, you can also write takeover of unlisted companies. Takeover of unlisted companies. Because for listed companies, there is a separate SEBI takeover code or regulation. So this in Companies Act, they only touch upon unlisted companies. Then we come to your section 237. 237 says that there is a merger in public interest. Merger in public interest. This is by central government. Okay. It's covered under your section 237. Now section 238 is also done. So we'll go to section 239 and section 240. 239 talks about preservation of books of accounts. Preservation of books of accounts. Okay, when there is a M&A. So the papers have to be preserved and it is set till central government orders. And last is the penal provisions, that if the provisions of 230 to 240 is not followed, then penalty will be levied. Okay, so you can take a screenshot of this and remember and quote it in your exam. Now we also go to see the form numbers. Now the form numbers given under your CAA rules 2016 are from CAA 1 to CAA 15. Okay, so there are 15 form numbers that we have to remember. All are very simple to remember as well. Okay, and we will take a attempt to memorize these as well. Okay, now very first thing is CAA 1. Now as we saw, it is compromise, arrangement and amalgamation. So very first one is about compromise. Okay, in compromise it is with whom? I told you compromise is with whom? With your lenders, with your creditors, where I go to the creditors, I'm sorry, I cannot pay the full money, please do some arrangement, some relaxation in interest, some give me more tenure, take instead of loan, take equity, some compromise, do it please, otherwise the business will shut down, you will also not get anything, even we will not get anything. So the creditors say okay, fine. Now whenever a compromise is being made, the creditors have to give a responsibility statement. Who will give this responsibility statement? So the creditors will give a responsibility statement that the compromise they are approving it with their open eyes and they feel it is in the interest of the company and themselves as well. So CAA 1 is done. Okay, so there is one form for compromise, which is your CAA 1, where the creditors take responsibility that yes, we are approving the compromise, don't worry, a statement has to be taken from them. Now let's come to CAA 2. Now whenever we have, pay attention to this, this is also divided in your similar manner, that is CAA this is through the NCLT route. Okay, as we had done above, the similar thing will come here. So CAA 2 to CAA 8. Okay, CAA 2 to CAA 8 is about NCLT route. It is about NCLT route. So can anyone tell me under which section is it given of Companies Act? Quickly. It is given under your section 230 to 232. Okay, so CAA 2 to CAA 8 is about NCLT route forms. Then can you tell me anything what is with respect to section 233? So 233 form numbers are from section CAA 9 to CAA 13. What does it say? That fast track mergers. A company, certain companies are allowed to merge in a very fast track manner where they don't require NCLT approval. This is given under your section 233. Clear? Now, what is those? We will also try to memorize. The very next one is 230. Okay, your CAA 14 is for what? CAA 14. So as I told you, section 235, 236, okay, and 238. See what we have done. This one, section 235, 236 and 238 is about takeover of unlisted companies. So here this will also be 235, 236 and 238. It is about takeover of unlisted companies. So this is about takeover, okay, of unlisted companies. Sir, is there a chance that we can learn all these 15 forms? Answer is absolutely yes. One you have already learned. I will take a shot at trying to making you all remember these forms also. So at least for this you need to participate with me, because once you learn these forms, the entire theory is super simple, because moment you remember the form, you will know that what it is talking about. So CA1 is what? About a creditor's responsibility statement. This is done in the case of compromise. Okay. Now let's see CAA2. CAA2. Now understand, this is in the case of NCLT route. NCLT route. So first will come a notice, an advertisement of the notice of the meetings of the creditors and members. So this is about notice of the meeting. Notice of meeting for M&A. Okay. So now normally what happens is, remember, we give a notice of meeting. Do you know? A meeting is done, a notice has been given. Normally, how many days notice is given? Normally, how many days, clear days notice is given? For M&A, normally you have 21 days notice, right? For M&A, you require a 30 days, not 21. 31 clear days notice should be given, and it will be given in CAA2. This notice is given to the members. As we send a notice to the members, we also inform the creditors of it in CAA2. So process starts with notice. 3 is also a notice. Sir, notice again. Now this notice is to the regulator. Now see, CA3 is for notice, but this notice, this also notice, this is also notice. This notice is for giving it to the authorities and to the central government. So notice to central government and different regulators, income tax authorities, etc., that we are merging and our tax is also cleared. So all those authorities mentioned is in 3. So we finished. This is all about notice. Notice. Now we see CAA4. Now what does CAA4 talk about? Reporting of the result. Now a chairperson will call a meeting of the members after you give a notice. What will happen? Shareholders will come. They will now vote. So if the shareholders come and they all say yes, we want to merge both the companies, they are extremely happy with the merger. So now the meeting results, what is there? So the reporting of results of meeting, result of meeting is given by chairman chairman to NCLT, that listen, they have approved it. Okay, this is also filed with the various authorities, that listen, whether we have approved it or not approved. So this is about reporting of the result after the meeting was done. What happened in the meeting? So that reporting is in CAA4. Now we go and tell NCLT, listen, everybody is happy. Shareholders also have a smile. Creditors also have a smile. Everybody is approved. So now we will file a proper petition. Now see, CA5 is for petition to NCLT to sanction the compromise and arrangement. First we tell them that listen, what happened in the meeting, and now we will file a proper petition to NCLT. A proper petition to NCLT to approve now listen to the wordings which I am using, because that will give it more clarity. To sanction the approved scheme. Can you tell me who has approved the scheme? Obviously the shareholders and creditors have approved the scheme that we are filing with the NCLT in CAA4. In CAA5 we are filing there is a petition which is made in CAA5 that has to be filed. Now NCLT will look at the order and NCLT will say, let me think whether I want to approve or I don't want to approve. Notice has been given properly. This guy has reported the results also, and now a formal petition is also filed. So why I shouldn't approve? The order will come in CAA 6 and also for different matter is in CAA 7. So pay attention. CAA 6 is 5 is done. Now we have CAA 6, CAA 6 and CAA 7. This is given by NCLT. This form is used not by us. It is going to be used by NCLT. This is an order sanctioning the petition. Order by NCLT. This is also order by NCLT. This order is for compromise and arrangement. This is for compromise and arrangement, and this is specifically for merger and amalgamation. So order regarding compromise will be in CAA 6 and order regarding amalgamation is in CAA 7. Now this is very simple, very clear, very sequential. Now we look at CAA 8. In CAA 8, it is something related to us. It is related to us. Okay, so we should be very, very happy. And you can mark it as important also. Sir, what is CAA 8 and how is it related to us? So whether you are a CA, CS, CA, CMA. So this is a particular document filed by the CA, all the three, Superman, Batman and Spider-Man, that is CA, CS, CMA, have to give a annual statement. They have to give a annual statement, okay, stating or certifying that the scheme is processed or is processing as per law. So every year, because mergers can take multiple years, so every year an annual statement is filed, annual statement by CA, CS, CMA, that the particular scheme is running as per law. See, what is CAA 8? It is an annual statement filed by CA, CS, CMA, okay, with the registrar every year. This is filed with the ROC every year until the scheme is properly completed, because scheme can go multiple years, certifying whether the scheme is complied as per the NCLT order or no. So this is done. We are done with the NCLT route forms. So notice reporting of results, giving the scheme for approval. Then the order will come in two forms, 6 and 7, and 8 is an annual statement by the Batman, Spider-Man and Superman. Okay. Now coming to the fast track forms. Now fast track merger is not every company cannot come under fast track mergers. So they have given you under section 233 that may be small company, a holding and wholly owned subsidiary, or a startup company and two startup companies, or startup with small company. So three types of companies are covered for fast track. Not all companies can come under fast track. Here you don't require NCLT approval only. So it's a good thing. It goes faster. So it is either a startup company or a small company, or the third one is holding company with its wholly owned subsidiary, 100% subsidiary, with its wholly owned subsidiary. Sir, what are the form numbers? Form numbers are CAA 9 to CAA 13. Sir, what are those? Let's see. Now we will try to memorize CAA 9, 10, 11, 12 and 13 as well. Sir, is there a sequence? Because I am getting very scared whether I will be able to learn or no. Answer is very, very simple. Fast track mergers under section 233. Okay, fast track mergers under section 233. Let's see. Very, very sequential, very, very easy to memorize. First, imagine if two the eligible companies who are allowed to go for fast track, they decide to merge. Don't you think they should ask that they invite objections from everyone, regulator, with the particular members, shareholders, that whether they have any objections or no? Because you are getting merged in a very fast manner. So better ask if anyone has an objection or any suggestion. Then when you're doing it, when you're getting merged in a fast track manner, you have to maintain that you're not going to get insolvent, okay, in between the process, because you are doing merger and in between only you shut down. So declaration of solvency will be taken in the next form, CA 10. Then comes the notice of approval of the scheme. When the scheme gets approved, now remember one thing, very very important, whose approval do they need and how much percent approval is needed. So write that down, that 90% approval is needed, okay, of the members also and of the creditors also. 90% of approval is needed. So once the approval is taken, then a notice will be filed that yes, we've got the approval, and we go to the central government. So basically you don't go to NCLT here, so it is without NCLT approval, okay, it is not in NCLT route, so it is a CG route. It is the CG route, which is a faster method, and in CG you have the ROC and RD who will be your communication. You don't have to go to court only. So then confirmation will be given with them on this, or confirmation order will come that yes, we are approving it. So once we inform them the 90% consent has given, then the CG will approve. So if the CG will approve it, will I have a smile on my face? Yes or no? CG has approved it, that is there. But if CG has not approved, then it will come under CAA 13. So the application by the central government will reject the scheme, that listen, I don't like it, and they will go and tell NCLT that listen, this guy tried to come in the NCLT, they come under the CG route, they didn't go to NCLT, and I don't want to approve it, so I will transfer the case back to NCLT. So I'll be sad, I went to central government for a fast track, but central government is not happy. Instead they called up the NCLT and they told NCLT that put this company under the normal regular NCLT route. So let me see your memory till what I have done. Okay, so I have completed all the CA 9, 10, 11, 12, 13. Let me see your memory. What is CA 9 for? How does it start? So I want to merge in a very fast manner, so it's not allowed. You have to first give a notice seeking objections. You have notice seeking objections or clarification from the authorities that listen, we want to merge, do you have a problem? So if they have a problem, then we'll have to listen to what they have. Second, in CA 10, now we have given a notice. During that time, we have to show that we won't get insolvent. So this is about declaration of solvency. Declaration of solvency, that we have the money, don't worry, we won't get insolvent. Now CA 11, what does CA 11 talk about? That if we get 90% approval, okay, so scheme has been approved by 90%, okay, we can call it as a requisite majority, 90%. So we become very happy. Now we send it to the central government. Now central government orders amalgamation, MNA. So their order copy will be in CA 12. But if central government is not happy, they don't sanction it, then central government sends or notifies NCLT to put this matter under NCLT route. So I'll be very very sad that I could not go under fast track method. So this is it. CA 9 to CA 13 form numbers are also done with respect to fast track mergers. Okay, and you can mark fast track merger as important even from exam point of view. Now coming to the last two forms is your related to your takeover. That's it. CA 14 and CA 15 is with respect to takeover. That's it. Okay. So could we memorize all the forms till CAA 14 and 15? So if 14, CAA 14 and CAA 15 is for takeover. Okay, so we are done with all the form numbers right from CAA 1 to CAA 15. Now, there are some NCLT forms also that will get hit. Okay, now we saw with the CAA forms, now we will see with the NCLT forms. Sir, what are the NCLT forms? How many are there? So we need to remember only these many NCLT forms. Only these many NCLT forms we do, it is sufficient to cover this entire chapter. So it starts with NCLT 1. Very, very simple, very, very easy. Now imagine when we go to NCLT, NCLT has also given their certain forms. That form is in NCLT 1. So for NCLT route, it is whenever NCLT route is there, then you will follow the application to NCLT will be in NCLT 1. So at least this we have to remember. It is used to initiate the process of compromise, arrangement and amalgamation by filing the application before NCLT. Second, NCLT 2 is a notice of admission. Sir, what is it? For this, you need to understand how does it happen in court. How is matter going to NCLT in court? So, let's say this is me. Okay, this is the companies. We go to NCLT. Okay, that we want to do XYZ things. So, NCLT form 1 we will file. Now NCLT, when we go to NCLT, the very first day they will not tell you which date you will get. They will process your application, they will see which is there, and they will inform you the date. They will inform the hearing date. Hearing date before which I have to go to NCLT. So NCLT will say that you come on 25th August at 11 case, your case will be listed on NCLT. So moment the company comes to know, they also have to intimate that listen, our application has been successfully admitted and we have been called on so and so date, and obviously we will inform to whom. So they will also come. So this is filed, okay, along with this to notify the tribunal and the relevant parties that the application has been admitted for hearing. So they will say that on which date it was admitted and when is our hearing date. So this we will also file it to the other parties and we will inform NCLT also that this date we are coming. We've got from the registry, we have got this date that here we will be listed. Now it is possible that this is like a notice, right? It's a notice of admission. It is given to everyone saying that let's meet on so and so date, NCLT has called us. This notice, it is possible that we will try to inform everybody, shareholders, creditors, but maybe they are not there at home, their registered address has changed. So here this same notice will be advertised in the newspapers. English, regional paper also it will be notified. So this advertisement of the notice of hearing will also be published. So this is a newspaper advertisement. It will be in NCLT 3A. So NCLT 1 is very simple. It's the main form. 2 is about notice. 3rd is about publication of that notice. 4, whenever you're filing, this always goes. You can always write it. It is a affidavit of service. Now all the documents that you give, it will be supported with a affidavit under affidavit under NCLT 4 saying that we have serviced all the parties, we have informed all the parties. It is a notice of service that we have serviced to all the concerned parties, that we have informed all the concerned party, and we write in affidavit that it is true to the best of our knowledge that we solemnly affirm that we have informed all the concerned parties. So it's an affidavit. It will be in NCLT 4. NCLT 6 is an affidavit that we have disclosed all the material facts to tribunal and we have not hidden anything from tribunal. Very, very simple, very, very easy. Can we learn the forms right now and finish it off? Answer is absolutely yes. First, NCLT 1. It is the application to NCLT. NCLT 2 is about a notice of admission. NCLT 3A is about what? It is about newspaper advertisement. Then comes NCLT 4 and NCLT 5, right? NCLT 4 and 5. No, NCLT 4 and NCLT 6. NCLT 4 and NCLT 6 both are about affidavit, that we are giving an oath that we have serviced the notice to all. We have serviced that notice has been given properly and everybody has been informed regularly. And here this is a affidavit about material facts has been disclosed. So that is it. NCLT form numbers are also done. Okay. Now we'll start with the sections 230 to 240. Just before that, you need to know all the form numbers that we have just done. Okay. Till here it is absolutely clear, everyone, yes or no? Till here. Okay. Sai, thank you so much. Till here, have I made myself clear? Yes or no? Then I will start with this section 230 to 240, and from your module we will start quickly finishing it off. Okay. So before I finish, I need a confirmation from all of you all that all the form numbers, section numbers are perfect. Yes or no? Quickly. Then I will start. I will continue with the lecture. Clear. Thank you. Okay. Quickly, everyone, just write clear in the chat box, then we start. Sham. Okay. Whatever others, I want all of you all to write clear in the chat box. Then I will start with section. Now you will remember the sections also. Internally also you will remember perfectly. Quickly. Okay. Shruti, great. Quickly use your fingers and type. Okay. Keep it interactive. I want all of you all to, put clear in the chat box. Yes, sir, in the chat box. So I will start with the second part. Akshay, Pradeep, great. Guru Prasad, clear. Thank you. Okay. Anyone else also wants to say that it's clear for them? Okay, great. Chalo, now we'll start with this part also. Just before I start, I give you 5 minutes. Okay. Okay. VV Gupta, thank you. Why should I hate you all? Okay. Great. Vignesh, great. Okay. Now I give you maybe 2 minutes to revise. Okay, revise what we've done. 2 minutes. Okay, because then it will help you. If you remember everything that I have done, then this chapter will get over as a cakewalk. Cakewalk is my responsibility. But this much what I have told you, just revise it. I'll take a breather, a water break. Till that time, you all will revise all of this and then you see beautifully from the module we'll start knocking it off. Okay, from the module this summary first I've given you. Now you start. Okay, so 2 minutes, I will come back, I'll take a water break and we'll continue. Okay, till that time, anyone wants to forward it to your friends, please inform them, just give a shout out, that's all. So I'm starting in 2 minutes. What's the time now? Maybe 5-minute break. I'll take a breather, 5 minutes. Okay, and we start by 12:35 p.m. That's it. Resume. If I'm audible and visible, please put it in the chat box quickly. So GTG in the chat box, and I will continue with the balance part of the chapter also. Quickly in the chat box whether I'm audible, visible, so I can quickly start. Okay, Akshaya, Vishnunath, thank you. Okay, great. So let's start. GB Media, great. Now we start with section 230 to 240. Now first, section 230 talks about the power of the members, creditors and company to enter into compromise and make arrangements. Okay, so section 230 subsection 1 says that where a compromise is proposed, compromises with the creditors, or an arrangement is proposed between the company and its creditors or between the company and its members, the tribunal may, on application received of the members or the creditors, order a meeting of the members or the creditors to be conducted in such a manner as the NCLT might direct. So as we know, section 230 to 232 talks about the NCLT route. The NCLT route. In this, I will tell you the entire process in short. Okay, so the process of M&A under NCLT route. Okay, so the very first thing it happens where the board of directors, the BOD, make application to NCLT. We make an application to NCLT. So then NCLT will then order a meeting. NCLT orders meeting of members and creditors. After that, then the approval is taken. So then the approval of members and creditors is taken. After that it is taken, then again we go to NCLT. Again we approach NCLT to sanction the scheme, to sanction approved scheme, to sanction approved scheme. Okay, then we go to NCLT, we say that listen, please approve the scheme after it has been approved by the shareholders and creditors. Then once NCLT will approve the scheme, NCLT approves scheme. This is the fifth thing. Okay, then we become very, very happy. Then company intimates ROC. Company intimates ROC, and this is done in INC 28. So this is the entire process. Please write it down. Okay, so when you are doing this entire sections, you will come to know, you will be able to relate. Here what we saw in subsection 1, that the company is making an application and the NCLT is ordering the meeting. That's it. See. Okay, so here when a compromise is proposed by this, the tribunal may, on application of the creditors or members, order a meeting. Very, very simple. Let's move ahead. The form in which we will approach NCLT, okay, to order the meeting, etc., it is in NCLT form number 1, and it is along with NCLT form number 2 that it is to be filed with the tribunal that the relevant parties has been informed regarding the proceedings. So NCLT 2 form is about admission, that we have filed, we've got it admitted, and the date of the hearing has been notified to all. This is given with NCLT form 6, where a statement of material facts has also been disclosed. So let's see in the very next section. We come to subsection 2. This is section 230 subsection 2, that the company who makes an application shall disclose by affidavit in NCLT 6 to the tribunal that all the material facts has been disclosed by the company. Okay. Now so there was a case law in Morphine Limited versus Regional Director, where it was that the material fact that an investigation was going on, they did not disclose that an investigation was going on by CFO. So we filed to NCLT, but we did not give a important fact to NCLT. NCLT dismissed the entire application for M&A. They said that you are trying to fool us, such an important fact you didn't give. So therefore you have to give in NCLT form 6, you have to disclose all the material facts. A affidavit that we have disclosed all the material facts. Then you will also give in your NCLT 6, you will tell them if reduction of share capital is proposed, if any, if a corporate debt restructuring is being done, that when there is a compromise, debt can be restructured where a debt can be converted into equity, etc. And 75% of the creditors should approve that particular scheme. A statement has to be given by CAA 1 that this is all with respect to compromise with creditors. We take 75% of their consent. We also take a creditor's responsibility statement in CAA 1 that according to the creditors, the scheme is in the interest of the company and their interest too. Okay. All the details will be given, whether they followed. A valuation report will be filed. Okay, valuation report is what is the cost of the debt, debentures, shares if they are giving, what is the valuation, that all has to be done. Now we are coming to very, very important subsection 3, notice of meeting. Sir, you are told in CA 2 a notice has been given. A notice will be given to all the creditors, members, debenture holders, everyone. And this notice, most important, is your CAA 2 is about notice to creditors, okay, and members. It will be 30 days notice. 30 days notice. Normally notice of meeting is 21 days, whereas for M&A it is a 30 days notice. It shall be accompanied with all the facts of the M&A will be given. It will also be placed, the particular notice will be placed on the, if it is a listed company, on the stock exchange website along with the company's website as well. Now, notice to provide for voting. Now again, very simple. Once we give a notice, in the notice of the meeting they also say that you can appoint a proxy. So about voting, you can vote yourself or you can appoint a proxy. So notice of meeting shall provide, the notice of meeting shall provide that they can attend themselves or they can vote it through a proxy as well. Now very, very important, who can object to a scheme? Mark it as important. Now imagine we presented a scheme to the particular NCLT. Now someone doesn't like the scheme, they will go and object to the scheme. Okay, so they are extremely unhappy, and the dissenting shareholders can go to the NCLT. Now imagine if I had only one share and I want to block the full merger. Is it allowed? I hold only one share and I want to block the full merger. Will it be allowed? They say, no, what nonsense. On one share you want to, a certain amount of holding is required to object to the scheme of M&A. So they say that any objection to compromise and arrangement shall only be made by persons holding not less than 10% of the shareholding, or if they are holding at least 5% of the total debt of the company. So who can object? Who can object is those who are holding 10% of shareholding of the company, or they are holding 5% of total debts. So we can say that you have some substantial money. These people can object to the scheme. Everyone else who has less than this cannot object to scheme of M&A, especially if everyone else is approving. Now, this notice to the regulators. So we saw notice to the members is given in CAA 2. In CAA 3 it is given to all the regulators. So mandatorily you have to give it to the central government, ROC and income tax authority. So we can say NOC from income tax authorities. CAA 3 is a notice to the regulators. Now if you are a sectorial company, for example there is a sectorial regulator. For example banking company, then you have to take RBI approval. If you are listed on stock exchange, SEBI approval. Okay, if you are any other insurance company, then you have to inform the IRDA also. So specific regulators are also there. So we have to inform them in CAA 3. Okay. Now, market is important. Did I ever tell you to learn a subsection also? Here, section 230, subsection 6. Market is important. It tells you the super majority is needed. Super majority consent for M&A, for merger and amalgamation. A super majority. Sir, what is a super majority? You tell me, to approve a scheme of M&A, merger and amalgamation, which kind of resolution will be taken? Special resolution or your ordinary resolution? What do you think? So here we will take a super majority resolution, or it is called, many people only know that there is ordinary and special resolution. There is another resolution which is called as extraordinary resolution. Extraordinary resolution. This is taken only in M&A, in mergers and amalgamation under section 230 to 240. It's called as extraordinary resolution. Sir, what is that? How much percent consent is needed? So the answer is very simple. It is 3/4 in value, 3/4 in value, and majority in number. Majority in number. So consent of people, those who are holding 3/4 in value, representing 3/4 majority in number, consent is to be taken. So these many people's consent is required. Sir, can you explain? So, and also remember, only those who are present and voting. So we will take the consent of those who are present at the meeting and they have voted and voting. So they should be those present and voting. So those who had come at the meeting, present and voting. So those who have not voted, even if the members are there or they have abstained from voting, they are not to be counted. We'll see. Let me explain. First, let's say there is A, B, C, D, E. Okay, clear to you? Now A has given has shareholding of 75%. 70%. He holds how much percent shares? 70% shares. This guy holds 10% shares. This guy holds 5% shares. This guy holds 5% shares. And this guy holds 10% shares. Okay, so this is the shareholding. Now imagine if these two have approved. If these two have approved, can you tell me a special resolution has been passed or no? So special resolution requires 75%. These two are 80%. So special resolution is passed. But in extraordinary resolution, it also requires majority in number. Head counts will be done. So it is not majority in number. So extraordinary resolution is not passed. We need an extraordinary resolution. So if I tell you that not A, B and C have approved, then we'll say yes, 3/4 in value is also covered and majority in number has also been covered. If I tell you another thing, you tell me. If I tell you B, C and D have approved, B, C and D have approved. So majority in number is covered. Majority in number is covered. 3/4 in value is not covered. So it will not be approved. So for this, we have to see that the approval should come from at least 75% in value, representing majority in number. So both the conditions has to be, for head counts also majority has to be there and 3/4 in value. So how they have written it? Very simple. Section 230 subsection 6 says that a meeting majority of persons representing 3/4 in value, okay, should agree to the scheme. Then the scheme will be binding on the company, on the everyone, on all creditors members. Then order of tribunal can come sanctioning the scheme. So now obviously when everybody is approved, NCLT can order. Now what all orders can be given? Now they give examples of NCLT powers, what all orders by NCLT they have given. So NCLT can tell you that, transfer all the assets, transfer the liabilities, protect the minority shareholders, convert your debt into equity, any kind of everything can be ordered. So anything under the sun can be ordered. So this is the powers. Compromise is there, then they can convert debt into equity, preference into equity. They can say protect the creditors. Those who are not agreeing, we can say that the dissenting shareholders give them some money. Okay, so any kind of variation can be approved. They will see NCLT will ensure that any of the orders can be passed, provided NCLT will see that everyone's interest is protected. Next, auditor's certificate. Now finance is a very important part. In every major kind of transaction, financial advisor consent is taken. Here we are talking of auditors. Those who are checking that yes, the balance sheets were proper, the merging and everything is done properly. So no compromise or arrangement shall be sanctioned by an NCLT unless it is certified by the company's auditors, okay, filed, that it is in conformity with the accounting standards prescribed. So you can mark it as important. That M&A requires auditor's certificate that accounting standards are followed or complied with. Very simple. Let's move ahead. Then we come to the final part. Once this is done, I will say that the merger is completed, process is completed. What is that? After NCLT gives consent, then I have to file with the ROC within 30 days. The order of the tribunal is filed with the ROC within a period of 30 days from the receipt of form INC 28. Once I have got the NCLT approval, I start dancing. Then I have to remember, I have to inform ROC also. So ROC will be intimated in form number INC 28 within a period of 30 days from receipt of the NCLT order. Okay, INC 28 is very important. Clear? That is when I will say everything is completed. Now, mark this also as important. It's a very simple concept. Okay, it's a simple concept, but let's understand what it is. Now, if the creditors and the members are giving in writing that listen, we have already gone through the scheme, we have already approved it, we don't want a separate meeting only. So can NCLT dispense? Dispense means exempt the calling of the meeting of members and creditors. So the answer is yes, you can dispense if consent has been taken off 90% in value and they have agreed by an affidavit that they are fine. So can NCLT dispense? Dispense, another word. What is the meaning of dispense? Exempt. Okay, or you could say not hold it. Okay, waive off the meeting of members and creditors? It's a very big thing. Can NCLT dispense it off? So the answer is yes. If 90% of members or creditors approve, then it's fine. If members approve 90%, then we'll waive off members meeting. If 90% of creditors approve, we'll exempt creditors meeting. Okay. In Vishwa Bank Limited case, it was ruled that secured creditors can be waived off if consent has been taken. However, if secured creditors have given consent, but then obviously you will still have to hold shareholders meeting and unsecured creditors meeting. So whichever class is giving 90% consent, we can exempt their meeting. Rest classes, so we will hold, na? Unless they have also given consent. Then we come to subsection 10, very simple, that if a buyback is being done, companies buying some of the shares, then they have to comply with section 68. In the scheme of M&A, if buyback is being proposed or some of the shares are bought back, then section 68 to 70 has to be complied. That is what they have given, not very important. If it is a listed company, then obviously you have to follow the takeover code prepared by SEBI. SEBI SAST regulations 2011 have to be complied. If any person is aggrieved, imagine a merger is being done and one person is continuously crying. Okay, he cannot stop his tears only. He cannot see the merger being done. So what advice you will give him? That you have a right, whatever happens, you can file NCLT 1 and file your grievances with the NCLT. Clear? That is given. Now there was a case of Reliance Jio, where Reliance Jio, what did they do? They structured the scheme in such a way that they got a lot of tax benefits. So Reliance Jio case, they structured the scheme. In a way that it reduced their tax liability. So is it allowed or not allowed? Now, during that time, it was within the purview of law. It was not a case of tax evasion. It was a case of tax planning. Okay, versus tax evasion. See, tax evasion is not allowed, but tax planning is allowed. And Reliance Jio had done tax planning. So, mere fact that a scheme has results in reduction of tax liability does not mean that the scheme is invalid. It can still be a valid scheme. Fair enough. Let's move ahead. Okay. Now we come to the next one, section 231. Sir, what is section 231? Very simple, that NCLT has the power to enforce the scheme and supervise the scheme. I'll ask you a question. Who supervises the scheme of M&A? NCLT. That is what they have given. As per section 231, when NCLT tribunal makes an order under section 230 sanctioning the scheme, it has the power to supervise the implementation of scheme. Very simple. So I can write in simple words, NCLT, okay, supervises scheme of M&A. Okay, any matter direction NCLT will give. If what happens is someone acts smart, there is fight, there is in the meeting, there is violence, someone has taken a chair and broken the chair on the chairman's head. So NCLT will say, what is going on? If they feel that the scheme is not being implemented properly, they can even act as a very strong force. They can say that if you cannot implement the scheme of M&A, I will order winding up of the scheme only. Winding up can also be ordered if you do not comply or the scheme cannot be implemented satisfactorily, every time you all are fighting, shut the company down. This is an extreme measure. Power has been given to NCLT so that they can scare the hell out of both the companies. Okay. Now, section 232. Now, in section 232, it's very simple. When NC, it talks about effect of NCLT order. Sir, what do you mean by effect? Now, imagine if company A is there and company B is there. They both are merging and they become company AB. Clear? So now when they are merging, company A will shut down, company B will shut down, and they will start work together called as company AB. Hero shut down, Honda shut down, they can come together and start Hero Honda. So when NCLT approves the scheme, when NCLT sanctions the scheme, all the assets of A will go to AB, all the assets and liabilities of company B will go to company AB. Okay, if there are shareholders out here, there are shareholders, they were holding shares of company A, they will get shares of company AB, will get shares of company AB. So if I'm a shareholder of A, I'm a shareholder of B, then I don't have to worry because my company shut down. New company will issue me the shares. This happens in M&A. So this is what they've given. Let's see. The tribunal has the power to call the meeting, we know. When the application is made under NCLT 1 and it is shown to the tribunal that it is involving mergers, amalgamation, that under the scheme that the properties will be transferred, okay, liabilities will be transferred, and NCLT is satisfied, and the NCLT will order a meeting of the members. And so this is like about the initial part, that if it comes and say NCLT is satisfied, they're going a little backward, where they're saying that listen, you come with me in NCLT 1, I have gone through the scheme, I think it is proper. Then they will say conduct a meeting. Now the main part will come. I'll tell you what I'm saying here. This one is important. Effect. Okay, but let's write a few points again. Circulation of the documents. So let's go back. Then all the documents will be circulated. Okay, the notice of the meeting, everything. And now this is the important part. Very simple. It's very logical also. That NCLT, the tribunal, after satisfying itself, may order the sanctioning of the compromise and arrangement, where the following provisions will be made. Assets will be transferred, liabilities will be shared, allotment of shares will be done, dissolution of the older company will be done, protection of the dissenting shareholders, those who are unhappy, they will be given some amount. If there is NRI, then we will tell that, if a company was shut down and there was few foreign shareholders, then you will have to also follow the FDI RBI norms. What will happen to the employees? All of this. If the company is being from listed is becoming unlisted, so all the things which are issues, NCLT will resolve or give a clarity. Okay, this we've done. Now, one important point is the statement. This we've done every year, annual statement. What is it? It's a annual statement by Batman, Superman and Spider-Man, that the scheme is being worked as per NCLT order. So this is filed every year till the scheme is completed. So every company in relation with the order shall, until the completion of the scheme, file a statement in form CA8 with the registrar every year, duly satisfied by CA, CS, CMA, that the scheme is being complied with the order of NCLT according to the NCLT order. So with this, we are completed with section 230 to 232 and the NCLT route. Done. Now we will start with a very fast manner, or if you want to merge in a very fast manner, you don't want to go to NCLT, it's such a long process. So it is called as fast track merger. In fast track merger, going to NCLT is very time consuming and cumbersome process. Instead, company law has said that, listen, under section 233, few companies, we'll see who it is. You can take a note: small companies, holding with its wholly owned, and startup companies. So 3 companies have been covered who can go for fast track merger. In fast track merger, they don't require NCLT, they don't even have to look at NCLT's face. They will directly go to central government and resolve it. There is no need to approach NCLT. Then who you will approach? We'll see who you will approach. You have to remember the rules. Market is important. Section 233 read with Rule 25 talks about fast track mergers. Concept clear? Yes, very simple. Let's move ahead. Okay, what is it that section 233 subsection 1 is saying? That a scheme of M&A may be entered into by 2 small companies, a wholly owned or a holding company, and such other class as may be prescribed. Now, what class has been prescribed? 2 or more startup companies or 1 startup with another small company has been permitted. Market is super important. So entire fast track merger is important. Therefore, I am telling you, remember the Rule 25 also. Now, once this is there, approval of the above scheme will not require approval of NCLT. Okay. So how it will be done? Let's see. You have to invite objection. It starts with, remember we had done few form numbers, form number 9, 10. So it starts with inviting objections from the ROC, etc. This is done in your CAA 9. Okay. You have to consider the objections and then file a declaration of solvency. This will be done in CAA 10, that we are doing a fast track, we will not get insolvent. And then we get a approval from the shareholders. Now, how much percent consent approval is needed? 90% approval is needed of the members and the creditors. Okay, this is reported in your CAA 11. Okay, 9, 10, 11 is done. 12 and 13 is very simple. CAA 12 and CAA 13. This is a happy phase. This is a sad phase. Why, sir, happy phase? Because it is approved by central government. This, it is rejected. So then central government intimates NCLT and tells NCLT that I don't want to do it in fast track. You take it in the NCLT route method, and then section 230 to 232 will apply. So if central government has rejected the scheme, then you have to go under the regular route only. So procedure is very simple. What is the procedure? Board resolution. Both the companies will pass a board resolution. They will take a invite objection from the ROC, official liquidator in CAA 9. Declaration of solvency will be in CAA 10. Shareholders approval, creditors approval. 90% approval will be taken. Then this approved scheme, now pay attention to this one part, okay? There is something special about CAA 11. CAA 11. CAA 11 is where the approved scheme is there, right? CAA is approved scheme. This is filed in a special form, filed in form GNL1. This is filed in which form? GNL1, and this is filed by the transferee company. This is filed by the transferee company, the buyer company who is there. After the merger, who is there, they will file this GNL1. Sir, what is it? See, when the scheme is approved, I told you scheme is approved, that will be in CAA 11. But this is not an independent form, it's just a format for approval of the scheme. So what happens is there is a form which is called a general form, GNL1. This is a general form, GENE, general form. Okay, so sometimes when we have to file and a particular CA11 is not a form where you can readily file in ROC. So this goes as an attachment. So this CA11 is an attachment to GNL1 form. Okay, because this is just a scheme which has been approved by everyone. So to file, there is a particular format for filing. So that you have to download GNL1, fill all the details, and then attach CA11. So that is the only special thing about CA11. The transferee company will file the approved scheme in CA11 and GNL1. That's it. Now, one is a happy face. Sir, happy face. Quickly make the happy face. So this is the happy face. So happy face is your CA12. What happens is, if no objections are there, central government doesn't find any objections only, okay, then, and it feels that it is in public interest, then they will give a confirmation order in CA12. NCLT 11, if objections are made by ROC. Objections are made by ROC. So central government will say, listen, objections are there, I don't like it, I'm rejecting the scheme. And we will pass an order that don't come in fast track method, order to NCLT. Order will be given to NCLT that you take up this matter. So this will go to CAA 13 to consider the scheme under the regular route. Very, very simple, very, very easy. Okay. NCLT will give a direction. Then upon receiving an application from NCLT, from central government, NCLT will then take up the matter and then pass the judgment as it deems fit. Okay. Once NCLT has passed the order, obviously, whenever NCLT passes an order, we have to file INC 28 reporting the NCLT order to ROC. So always remember, INC 28 is about NCLT order. Always, whenever NCLT gives an order, it goes to ROC under this form. See, company gets an order from court. This order copy has to be filed with ROC. Okay. Effect of the scheme we've already done. What is the effect of this scheme? Just we know assets will be transferred, liabilities will be transferred. The loan or the charge which are there on this company, that will now be there in the new company. Finish. So, for example, this is company A and this is company B. They both are merging and becoming company B. Let's say they all small companies. So it will come under fast track merger. Yes or no? They will come under fast track merger under section 233. All the assets will be transferred. See, all the assets will be transferred. Liabilities will be transferred here. This company will shut down. This company will shut down. And this company will now operate. They have fused together and they have continued. Now, one important question, that this company had taken a loan. It had a pending loan. And this company had a pending case, pending litigation. Now they had a pending litigation, pending loan, and the company is being shut down. So can you tell me that what will happen now? They are transferring their assets, right? So they are called as, both these companies are called as transferor company, and this is called as the, who's getting it is called as the transferee company. To whom the assets are transferred are called as a transferee company. So the pending litigations of the transferor company, the pending charge on of the transferor company, the pending whatever, will now become that of the transferee company. Now company AB will pay the balance loan and the company AB will file the pending case. That is what they have given. Okay, continuation of the legal proceeding, nothing happened, it will continue in the transferee company name. Okay. So we saw that a fast track merger requires approval of shareholders, creditors, central government, ROC, official liquidator. All the central government authorities has to give approval. So we saw the form numbers also and we are sorted. Now we'll see a very important section again, which is about cross-border merger, which is given under section 234. Sir, what is a short cross-border merger? First, let me tell you the section number. Section 234, read with Rule 25A. Rule 25A talks about cross-border mergers. Cross-border merger. Sir, what is it? Can you tell me in short? Very simple. It's a Indian company and a foreign company merging. That's it. So since one is a foreign company, okay, okay, they become a merged entity. So the foreign company is there. So only one additional regulator will come. So the additional provisions are, first of all, they have to comply with section 230 to 232. So a cross-border merger will have to follow the NCLT route. Market is important. NCLT route. So by default, the entire route to be followed for a cross-border merger is NCLT. Obviously, we will not put it under fast-track mode of such a big merger. Additional provisions, what are there? Let's see. What is the additional provisions that in addition to the NCLT route, what they have to follow? So the very first one is they require RBI approval. They require RBI approval. One. Clear? Second, additionally what they have to follow, that the jurisdiction, that is the company of this foreign company, they should not be of Pakistan, China, anything. So jurisdiction should be approved. Should be a approved jurisdiction, which government will say, listen, they are complying with money laundering, we are having friendly relations. It should not be in a which is anti-government, anti-India. Those jurisdictions are not allowed. So two important provisions we have to keep in mind. Let's see. First, Rule 25A, as I told you, cross-border merger. Sir, which rules will apply? Same. The rules of section 230 to 232 will apply mutatis mutandis. This is what you will write. Okay, for companies incorporated in a jurisdiction which is other than India. Second, you may make additional rules, but in consultation with RBI, new regulator will come in. And subsection 2 says that you require prior approval of RBI. Very, very important, as I told you. This is the additional thing that you have to follow. Now, Rule 25A, what does it talk about of the CAA rules? Merger involving foreign companies are allowed, but they require approval of RBI. Jurisdiction has to be those which are listed in Annexure B. Okay, so Annexure B gives you a list of jurisdiction details. It should fall only in those jurisdictions, then only we can merge. Okay, and the valuation of the shares, etc., should be done as per a valuer, and that valuer should follow the internationally accepted accounting and valuation principle. So very simple. It's a foreign company, so we'll say you have to follow the international valuation standards which are there, that has to be complied. Okay, obviously I told you they have to follow section 230 to 232 NCLT route. Okay, now this is, you can write with land borders. So countries which are sharing the land borders with India, like Pakistan, Afghanistan, China, if we are merging with any of these countries which are sharing the land borders with India, we require additional approval. Okay, additional approval of central government, CG approval. Land border, then you require CG approval, and a declaration has to be made in CAA 16. That listen, we are merging with a or we are not merging. So the declaration has to be given whether you are merging with a land border country or no. Special provisions. Okay, so the annexure which I was telling you, annexure B, which we were discussing here, jurisdiction, right? See here, annexure B, jurisdiction. Jurisdiction listed in annexure B. So we will see what is that annexure B. Very simple given here. This is your jurisdiction related information. So what do you think? They have not clearly mentioned which country. They have said that you can comply, you can merge with any entity which is whose regulator is following the regulator of international standards, whose bank, central bank is complying with this. That's it. See, you can merge with any country who and any company who is of a jurisdiction whose security market regulator, that is security market regulator, like how we have SEBI in USA, there is SEC, Security Exchange Commission, like that you have a UK, you have a Dubai. So their securities market regulator is a signatory to the International Organization of Securities Commission called a ISCO, International OSCO, International Organization of Securities Commission. Okay, next, this is about securities market regulator. Then they talk about your central regulator, or it is of a jurisdiction whose central bank, like how we have RBI, China has a different bank, okay, Republic Bank. So like that, every country has a separate regulator, the separate central bank. That central bank is a member of the Bank of International Settlements, or is not identified, and that country should not be identified as anti-money laundering laws deficient, that they are deficient in following the anti-money laundering laws, or who has not made sufficient progress as told to them by Financial Action Task Force. So if a Financial Action Task Force has made an action plan and you're not complying with that, so we cannot merge with you. So ISCO, the other one is central bank. Central bank, this is your securities market regulator. Okay, and this is about money laundering, anti-money laundering laws. Clear? Then we can merge. Now we'll see your section. Now we are seeing your section 235, 236 and section 238. All these three are related to takeover of unlisted companies. Unlisted companies. Sir, why unlisted? Listed, there is a separate regulation altogether. SEBI SAST regulations 2011. Separate. So this in Companies Act they've only given about unlisted companies. So let's see. Very simple. There are few thresholds that you have to remember. Notice power to acquire shares of dissenting shareholders from a scheme or contract approved by the majority. Now, pay attention. That here you write this down, section 235. It is also called as compulsory acquisition of dissenting shareholders, shareholders. And one more line you can write, or you can also call it as takeover of unlisted company. Takeover of unlisted company. That's it. Okay, compulsory acquisition of dissenting shareholders and takeover of unlisted company. Very simple. Let's see. First, we require few thresholds to remember. 4 months, 90% in value, okay, CAA 14, 2 months, okay. So how many thresholds are there? And 1 month will also be there, and 1 month. Sir, how many thresholds are there? Very simple, extremely simple. So first they are saying 90%, then they are saying 4 months, then they are saying 2 months, and then they are saying 1 month. That is it. That is it. Done. Only these thresholds you understand and the topic is over. Topic is over. So what is it? Listen. When a acquirer is there, he wants to acquire a target company. So how will he do? He will give a notice, he will give a scheme, he will give an offer to target company shareholders. Let's say he'll give a offer to target company shareholders, to the shareholders of target company. Shareholders of target company, that listen, I want to buy your full company. I want to buy your full company and I will pay you so much money. So if I have given an offer, and in the offer I'll give you the full scheme, how much you will get, by when you have to give, when I will acquire. So moment I give that, everybody is smiling. They love the scheme because I'm giving them a very good price. Okay. So even I would want my company to be taken over. Someone give me an offer that they will give me double the amount on the shares. I'll say take it. I get one day I make my money double. So if within 4 months of the offer, 90% of the shareholders have approved. Within 4 months of offer, 90% of shareholders have approved scheme. So that means the scheme is genuine or not genuine? Obviously it is genuine. Then the acquirer law is giving him a power that listen, 90% or more have approved. So you can give in the next 2 months. From the end of the 4th month, in the next 2 months. See, 4 months everybody has given me a consent. In the next 2 months, I can give a notice to dissenting shareholders. That listen, 90% have approved, you are just 5, 10, 15, 10%. That I want to compulsory, that I will compulsorily acquire your shares. I will do a compulsory acquisition of your shares. So within 2 months I will give, and then in 2 months I will give the notice in CAA 14. Okay, notice to compulsorily acquire the shares. Acquirer will give. Now it is possible that moment the notice has been received, the dissenting shareholders are unhappy. So they will go to NCLT within 1 month. That's it. Concept over. So if within 4 months 90% of the shareholders have approved the scheme, then the acquirer can give a notice to the dissenting shareholders in CAA 14 within 2 months from the expiry of 4 months that listen, I will compulsorily acquire your shares, and if you are unhappy, run to the NCLT. So the dissenting shareholders, when they receive this CAA 14, moment they receive, within 1 month they have to run to NCLT, otherwise their shares will be compulsorily acquired. That is it, concept over. Let's read it and finish it off. Where a scheme, okay, has been within 4 months approved by not less than 90%, then the buyer or the acquirer may, within 2 months from the expiry of the 4 months, give a notice in CA 14 to the dissenting shareholder that he desires to acquire his shares. Now, moment you receive, the transferee company shall give a notice. Okay, the dissenting shareholders within 1 month, he will acquire the shares is given. You can write that if within 1 month they can go and write to NCLT, write to approach NCLT. Now, coming to section 236. 236. Now pay attention. Okay, 236 and then 238, and we are almost done. Okay, so now understand what is section 238. It is talking about majority shareholders, that is the acquirer, who is now going to get the majority share, 90% or more, will inform the company, okay, the target company, about the remaining shares and establishing a process of handling the funds and share transfers. Pay attention. Now the majority shareholder, who is the majority shareholder here? Is the acquirer. Is the acquirer. Okay. There is the target company. There is the target company. Okay. And there are the shareholders of the target company. Shareholders of target company, including dissenting shareholders. Including dissenting shareholders. Including the dissenting shareholders. So there are three parties. The acquirer. Okay, this is the first party. The second party is the company, target company who we want to acquire. And third is the shareholders of the target company. Concept clear? Yes or no? Now, once all this is done, the acquirer has got the approval, etc. So now he has to pay money, right? So he will tell the shareholders, he will tell the target company that I am ready to pay. You inform the shareholders. I will pay the money to the target company. The target company will pay to the shareholders, including the dissenting shareholders. In return, the shareholders will have to give what? Share certificate. And then these share certificates or share transfer will come. Here. Clear till here? Yes or no? So here the acquirer will have to show some funds. He will have to create funds in account. He has to make the funds in the account. That has to be verified. Only then we will take the share certificates and then give it to the acquirer. Concept clear? So this is what they will be telling you. Now at what value it will go? Valuation of the share and what will be per share price. Obviously it is as per the approval. For the dissenting shareholders, it will be also be as per the approval. As what is for others, it will be given. Okay, now when we find out the valuation of the share, if it is a listed company, see, if it is a listed company, there's never a problem to find the value. But because see, listed company will be the market price, will be the price that I have to give me minimum. In listed company, I have to find some valuation principles has to be identified. As per valuation principles has to be identified. Clear? This is what they will give you. Let's see and quickly finish it off. So this is not that important. So that is why we can just do the headings and close it. Purchase of minority shareholders under section 36. So even minority shareholders are there. Once we get 90% consent, if the acquirer gets 90% consent, he will notify the company of his intention to acquire the remaining shares also. So he will give his notice to the company that I will acquire the remaining, that is the dissenting shareholders also. Very nicely he will tell that I am offering to buy the dissenting shareholders. You can apply the registered valuer. Okay, normally obviously it will be given at the same terms and conditions as given to the others. Minorities right to sell. So now when the company informs, company is informed by the shareholder, by the acquirer. company will tell the minority shareholder, if you want to give it nicely, otherwise we have to forcefully take and give it to you. So now comes about depositing of funds. Who will deposit the funds in an account so that all the share, who's buying the shares? Acquirer, majority shareholder, will deposit the funds equal to the value of the shares he plans to acquire in a separate bank account. This money will be kept for 1 year, because imagine someone has gone out of India. So it will be kept, money will be kept for 1 year. Within that 1 year, anyone wants, they will put the shares, take the money and leave. So all the disbursement to the minority shareholders will occur within 60 days. So within 60 days, we will start giving the money to the minority shareholders also. Why they have kept it more than, even beyond 60 days, someone can come and say that, listen, I didn't know that this 60 days was there, and up till 1 year these funds are kept. So for example, funds are kept in the account for 1 year. So these funds are kept. Whenever any minority shareholder will come, he will surrender his share certificate, take the money and go. And this process should be completed within 60 days normally. But law is saying, listen, if someone doesn't come in 60 days, still we will not deny to them, because 1 year is there, right? So within 1 year, even after 60 days, the shareholder can come. We are telling the acquirer that whoever are ready, within 60 days buy and give him the money. Whoever are standing, within 60 days pay the money. Those who have not yet come, keep your money in the account. When they come within 1 year, you pay it off to them. Okay, so very simple. Then the share transfer agent will be appointed, who will transfer the shares. The share certificate surrendered. If you don't surrender, we will compulsory take it and then cancel all your share certificates. Now imagine if someone says that, listen, the shareholder had died. Now obviously there is a legal as going in court and fighting who is the real owner of the shares. So then that is why, if the deceased were there, then we will say that you can, even after 1 year also, up till 3 years, you can go and ask the acquirer that, listen, I had shares of this company. That time the shareholder was dead. Matter was going on in court. So now we have come. So the acquirer should be ready to buy. Okay. Now it is possible that the minority shareholders are crying and crying. No, we don't want to give, don't acquire. So the acquirer can give a higher price. Higher price can be given. However, then it has to be given to the other shareholders also. Okay, and they have to give to the other shareholders, extra money has to be given. In return, in other ways, if higher amount was given to majority shareholders, then that higher amount has to be given to the minority shareholders also. So remember that everybody will be acquired at same price. Okay, this is what it is there. Residual minority shareholders. So even if you company can be delisted, but you have to follow with the delisting laws. This is what they've said. Verify. Now this is we are doing is Rule 26A of the CAA Rules 2016. Very, very simple, very, very easy. See, if they're talking of purchase of minority shareholders held in Demat form, this is super simple. Super simple. Why? Because if it is Demat shares, you just have to create a debit in Demat account, a debit of shares in Demat account, and we will credit money in account, right? If it is a Demat, automatically your shares will be debited from your Demat account and funds will be transferred into your bank account. Demat is very simple. You don't have to destroy, get the share certificates, etc. So now who are the minority shareholders, etc. Verification will be done. Name, address, place, who are they, identify. If their shares are held in Demat form, you can notify the minority shareholder that they can, this is the cutoff date, okay, etc. A public notice will also be given that, you come, just intimating that of the full transaction that acquirer has acquired on this date. He is given to acquire your shares. So public notice will also be given. Now obviously being Demat shares, we also have to inform the depository about the public notice that shares will be taken, etc. Company secretary will ensure that the share transfers are done properly. Okay, the depository is informed and proper payment has been made to the minority. Okay, share transfer should go to the majority shareholders. If some shares are pledged or hypothecated, there is a loan on a shares, etc., then that will go to court, will decide what is to be done. Okay, now we come to the Rule 27 of the Companies Compromise and Arrangement Rules 2016. Very simple. How will you get the price? Offer price. A registered valuer will decide. For listed company, we never have a price in determining the price at all. Okay, because the the price which is listed on the stock exchange can be taken as the value of the share. Valuation report will be prepared justifying the price to the board of directors that the acquirer is acquiring at this price. This is proper, fair and just. For unlisted companies, some rules have been given. The offer price determined by the registered valuer is on the following factors. Price paid. So all these factors will be taken. The fair price, considering everything. Share price is the market price. And all the book value, net, all the fundamental factors will be seen. EPS, PE ratio, all this will be seen. So this is valuer will determine the fact. We are just seeing factors that he will consider. Factors to be considered by valuer. Okay, very simple. Then registered valuer will prepare a valuation report and will then justify the offer price. Okay. Then we are done with acquisition for compulsory takeover. Even 238 is there, that is also short. Okay, let's see. Section 238, registration of offer of shares involving transfer of shares. So very, very simple. He has to first, acquirer has to first ensure that he has cash availability to pay off. You have to register the transfer of shares. Very simple. You have, while registering, you have to give a circular in CAA 15, giving them all the information that what price is being sold. All the details of the transaction will be given. A cash availability, that the buyer acquirer has cash. Okay, and this particular CAA, the circular, giving them all the details of the scheme at which the acquirer is going to buy, why he is going to buy, what is his purpose, etc. All this will be given. Okay, this must be submitted with the ROC before it is issued to the shareholders. If shareholders have refused, if the ROC has refused that, listen, I don't agree, so then an appeal can be made to the tribunal. The appeal will be made in form NCLT 9, okay, with a affidavit in NCLT 6. So what is it? Let's write it down. That the acquirer can acquire shares. This is one simple point. Yes, he can. Second, registration of transfer should be done. Registration of transfer of shares should be done. Nobody can deny that he can. Share transfers will not happen. Third, acquirer has to ensure that he has cash. He has given a proper, he has cash availability is there. And fourth, a information memorandum in form CAA 15 has to be given to the shareholders. This CAA 15 will just cover all the facts, okay, which will be given to the shareholders. That is it. Now come to an important topic which is called as section 237. Mark it as important. 237 is about amalgamation of companies by central government in public interest. Something like arranged marriage. So this is a compulsory amalgamation of companies declared by central government in public interest. For example, Air India is a government company. Indian Airlines was a government company. Government said that listen, we feel these two companies, if they are merged, they will operate better. So they can merge it. Merged company can be done. Now this is in public interest. In public interest. Currently, if you see in 2025, 2026, government is planning to merge banks. Okay, in public interest. In public interest. Then listen, see, this company does separate compliance, this company does separate compliance, this company does separate marketing, this company does separate marketing, this company prepares separate accounts, this company prepares separate accounts. So why not merge them so that we will have the benefits of scale, we will have the benefits of working as a synergy. Maybe this management is very good, so it will be very good, so central government can order. So what is the rules? Very, very simple. You tell me, think about the shareholders. Shareholders is realizing that the shares are being completely taken away. So the government will say, don't listen, don't worry, chill in life, relax. But my company is, my shares are getting compulsory fused. Don't worry, if you get even, you will get the same amount of holding. The value of yours now and afterwards will remain the same. If it will reduce, you can go to NCLT. We will ensure that it is not, your interest is not affected. That's it. This is public interest. So we will think of a larger benefit rather than your objections. So power of central government, very, very important. When central government is satisfied that it is essential in public interest to merge two companies, then it will by an order provide for amalgamation of the two companies into a single company. Very simple. Litigations will be continued, loans will continue now in the new company name. Interest of the members, creditors will not be affected. They don't need to get scared. Every member, creditor, etc. will have the same interest as that he had earlier. In case if the interest is less, then he will be given compensation by the government. Very, very simple. If the compensation is not given, the aggrieved person can also go to the NCLT and prefer a NCLT within 30 days from it has been communicated to him. Now, central government, once they pass an order of merger, so they are saying that some things to be kept in mind, that no order shall be made unless we have informed a copy of the proposed order has been sent to each company concerned. So both the companies will be informed that listen, central government has passed an order to be fusing both of you all. We will give you all time to go in appeal. Okay, central government, if someone has objected, central government will listen to the objections. Okay, and very, very important, this is something specific only for you. The copy of every order made shall be laid before both the houses of parliament. Clear? So very simple. What is it? That central government orders merger of companies, okay, in public interest. So again, whose consent is to be taken? Nobody's consent is to be taken. Okay, this will be laid before parliament. Companies will be informed. They don't have to worry because they will get same interest in company. If they feel they are going to get less, then that much amount of compensation can be given. Okay, and if they are still unhappy, they can go to NCLT. That is it. Then we come to your section 239. Very, very simple, very, very important. Very, very simple and very, very important. So what is important here? Okay. So here what happens is government is saying, listen, once a merger is done, the books of paper, the books of accounts, the paperwork, the document, a merger document should not be disposed of except with central government consent. That's it. The books and papers of company which has been amalgamated, okay, or acquired under this chapter shall not dispose of without the permission of central government. So you require permission of central government. And before granting permission, the central government will appoint a person to examine the books of accounts and ascertaining whether any offense has been done or no. So if central government is permitting you, so before that they will, appoint a person to examine that no fraud has been done. So it is very important. Once they had asked for how long should you preserve the books of accounts of amalgamation, answer it should be preserved and should not be disposed of unless central government has given permission. And central government also, before giving permission, they will appoint to examine whether no offense has been done or no. Section 240 is about penal provision, that if any offense has been done, the officers in default will be held liable if section 230 to 240 has not been complied. And that is it. We have completed with the entire section 230 to 240 in complete depth, including all the forms, and nothing can come outside of what we have done. Thank you. Clear till here, everyone? Everyone's with me? Is this completed? Yes or no? Yes or no? Are we done with it? Yes or no? Just in the chat box. Okay. I want you all to put in the chat box whether we are done with it or no. You see your module full section 230 to 240 we have completed. Okay. So that is it, guys, for today. There is a small part which we will do next time. Okay. Guru Prasad, great. Thank you. Shakti, great. Okay, great. So there is just about first process and bottle also. This we'll see if we can cover it at some other point. Just a small half an hour session is there. Okay, so with this I have completed this entire chapter and I will see you all in the next session. I will put it on online when I'm going to take the first what is hand bottle rule. Okay, so that is it, guys. Take care. Bye. And don't forget to like the video and share it amongst your friends as well. Okay, especially if you are in South, please inform all your friends, because sometimes students say that they didn't know about our classes only and that we are taking these lectures. So it's your responsibility to give a shout out to all your friends. Okay, guys, take care. Bye.